lords, my lady, I was taking you to the Court of Appeal judgment in Phillips and Nussberger, which is in the authorities bundle at tab 8. And just by way of background, this case concerned applications made by the claimant under CPR 310 and 69. Factual background is the Swiss court had served a package of documents on Ms. Nussberger without a claim form, as was required under the relevant rules for service out of the jurisdiction, because the English court had erroneously stamped on it not for service outside the jurisdiction. That was an error by the Swiss court, not by the claimants. Ms. Nussberger learnt of this and sought to take advantage by issuing proceedings in the Swiss court and arguing that it was the court first seized for the purposes of jurisdiction. So if I could just take you to one paragraph in the Court of Appeal judgment, which is the judgment of Lord Justice Neuberger at paragraph 6, as he then was, at paragraph 63 on page 133 of the bundle. And if I could just ask you to read that one paragraph. It's a simple point because there was some discussion in the court below as to whether or not the previous Court of Appeal judgments in Venus and Elms had been before the House of Lords in in Phillips. And we say it's clear that they were considered and expressly considered by and before the Court of Appeal. And we say then they must have been, at least by indirectly in front of the House of Lords. And that, we say, was correctly recognised by Mr. Justice Morgan in the judgment below in these proceedings in paragraph 89 of his judgment. So then if that background, I can take you to the House of Lords report in Phillips, which is at the next tab, Authorities tab 9, and ask you to turn to the comments made by Lord Brown on page 153, paragraphs 30 to 34, and I would ask your Lordships, your Ladyship, to read those paragraphs 30 and 30 to 34.
Nine is what's now 616, right?
That's right.
Dispensing with service.
Yes.
And that was the basis on which they actually decided the case.
Yes. So, my lord, those comments, as your lordship said, were strictly obiter, in that the court ultimately exercised its power under Rule 6.9. But I do make the point that the statements made by Lord Brown there were fully reasoned, and he concluded that in principle a defect in service was capable of being remedied under CPR 310, even though a power under 6.9 would have been available to dispense with the requirement for service. And it may very well be that I don't need to go that far if your lordships are with me on my interpretation of the Court of Appeal judgments that I took you through in Elms, Venus and Steele, and the circumstances of this case as to the nature of the error of procedure. But clearly the Lord Brown's views expressed in these paragraphs, which have been applied in a number of subsequent first instance cases, suggest that 310 is, as he says, a most beneficial provision to be given wide effect, even where there may be a rule that could also be invoked.
Was Lord Brown focusing on a situation in which a rule positively said you can't do it?
I apologise, I didn't catch that.
Was Lord Brown focusing on a situation in which another rule positively said you can't do whatever it happens to be?
May very well, no, it may very well, I don't think that, certainly that argument was not made, that it could not be done under 6.9, so it wasn't like the retrospective application of 6.9 that he considered in the Court of Appeal in Elms. He says at paragraph 34, it may not be necessary to invoke Rule 6.9 at all in order to declare the service of documents effected on the 19th of January to have been valid and effective, referring there, I think, to 310, but assume, as both courts below clearly thought, it's necessary for the court actually to dispense with service. Can that be done? And then he goes on to hold that it can. So, my lord, we would say that it is consistent with our submission that Rule 310 was certainly available as a matter of principle in the current appeals, because the application of the rule in 310 was available to remedy an error of procedure consisting of a failure to serve the sealed claim form pursuant to paragraph 8.1 of Practice Direction 51.0. There is no suggestion that although, I mean, the highest I understand the respondent's case to be made against us is that other rules were available. But that is very different from saying, which I understand to be the dicta, the ratio of the Court of Appeal judgments and Lord Brown's approach in Phillips. That is very different from saying what you're proposing to do is explicitly prohibited by other rules. It's not sufficient that other rules may have been available in a case such as the present case. And in fact, all the first instance authorities that were before the judge, Integral, Baroda, Piepenbrook, Dory, all considered alternatives, including 310, generally 615, 616, 310, as did the judge below in this case. So those are my submissions on whether 310 was available as a matter of principle. The judge below took the issue no further because he said it's not available as a matter of principle, so I don't need to consider whether or not to exercise my discretion. The respondents contend in their respondent's notice that even if 310 is available in principle, this court should decide not to exercise its discretion because, and this is the simple point made against me, the exercise of such discretion would cause prejudice to the respondents because they would be deprived thereby, and I quote, of a limitation defence. I'll come on to what that actually means in a moment, but in the circumstances of this case. But in that regard, you shouldn't exercise the discretion because it would be prejudicing us by depriving us of a limitation defence. They rely on the same first instance authorities, and I'll take you to them, but just by way of introduction, they're specific paragraphs 33 of the judgment in Integral, paragraphs 15 to 20 of the judgment in Baroda, and Piepenbrook in paragraph 82.5. But my submission on these authorities, of course they're all just first instance authorities, but these and other authorities we say no more than the following, which is that prejudice caused to defendants from a loss of a limitation defence is simply a factor to be weighed in the balance by the court when exercising its discretion, together with factors including, and the court says almost most importantly, whether the error itself in procedure caused any prejudice to the defendants, specifically whether, despite the error in procedure and service, the defendants nevertheless knew a claim had been made against them, or knew further the nature of that claim. So that issue is also one that was of particular importance in weighing up the balance in exercising the discretion under 310. Also, obviously, of importance, we would submit as a prejudice to claimants from being barred from proceeding with claims, or at least the full ambit of their claims, thus giving effectively the defendants a windfall arising from, in what a number of these cases might be seen as a technical error. And that is the language that's been used in the cases. So as briefly as possible, I'll take you to the first instance cases on which the respondents rely, and the first one of those is the judgment of Mr. Justice Popperworld, as he then was in Integral, which is Authorities Bundle tab 11. And I think I can deal with this relatively quickly. The defect in that case was that a claim form was served by email when there had been no agreement to that method of service. And in any event, it was served 5 days late. And that's paragraph 11, you can get the facts. If I could just ask you to turn then to page 181 of the judgment. Paragraph 21 sets out CPR 310. Paragraph 22, the judge refers to authoritative guidance, which is what I would ask your lordships to, how I would also ask your lordships to approach the dicta of, or the statements of Lord Brown in Phillips. Authoritative guidance on the scope of this provision is to be found in the decision of the House of Lords in Phillips. He sets out that judgment, in what that judgment was about. In paragraph 23, he quotes from Lord Brown's statements at paragraphs 29 to 34 of the House of Lords judgment in Phillips. And then at 24, on page 184, the judge says that although these were not strictly part of, or these were not part of the ratio, and what was said was no more than it was at least arguable, these were considered statements, and the language in which they were expressed suggests more than mere arguability, and I would adopt that comment on what Lord Brown says in Phillips as the last sentence of paragraph 24 of Popperworld's judgment. And then the paragraph on which the respondents rely is paragraph 35 of Popperworld's judgment, which is on page 186, Ms. Justice Popperworld's judgment, page 186. And I would just, over the page, if I would just ask you to read that to yourselves, and I will make a point on it. my lord, my lords and my lady, I would simply say that that paragraph does nothing more than recognise there was no prejudice to the defendants on the facts of that case. It says nothing about limitation defences. And it certainly doesn't go far as to say you cannot exercise the discretion under 310 if it causes prejudice to the defendants. Then if I may take you to the Bank of Baroda case. I'm sorry, yeah, I should correct myself. I said that the case integral was about service of the claim form, but it wasn't. It was about service of the particulars of claim, which can be found in paragraph 11, just in case I don't want to mislead the court. Sorry, then moving to the Bank of Baroda judgment, which is a judgment of a Deputy Judge Cockerell, as she then was, in sitting as Deputy Judge in the Queen's Bench Division, tab 13 of the authorities bundle. And again, dealing with it as briefly as I can on the facts, it concerned an application by the defendants under CPR 11 for a decision that there had been defective service in that only one copy of a claim form and 4 response packs had been served on the 4 defendants when 4 separate copies of the claim form should have been served. And then if I can ask you to turn to page 233, the judge starts her consideration of defective service just above paragraph 10. I can take you to paragraph 15. She addresses the application of CPR 310. I'm not going to read that out. She refers to previous judgments of the first instance courts in United Utilities, which you'll have seen is also mentioned in the White Book notes. And she says in paragraph 16 that United Utilities is a very useful summary of the principles and reasonable authorities in the area, and refers to Lord Brown's obiter dictum in Phillips. In 17, she refers to Integral Petroleum, the judgment of Popperworld, and then she goes to her decision on the facts of that case. And if I could ask you to read paragraphs 18 and 19. Make 2 points on that. First of all, I would highlight what she said in paragraph 19, where she also made the distinction which we rely on between cases where a procedural step is taken defectively rather than omitted or performed directly contrary to a rule. So again, we rely on that distinction, which has been applied in this case as well. And again, on the prejudice to defendants and limitation, all this judgment says that on the facts of that case, including the fact that there was no, as a matter of fact, limitation defence in that case, 310 should and can and should be exercised. So again, it's simply noted that on that case, this was one of the factors to be taken into account, together with the fact that the defendants were perfectly aware of what the case was that was being made against them. Finally, Piepenbroek, which is at tab 18, and that's a judgment of Mr. Justice Nicklin. So tab 18 of the authorities bundle, the judgment of Mr. Justice Nicklin in Piepenbroek. That, again, dealing with as briefly as I can, was a libel claim which had been issued by Dr. Piepenbroek, and the procedure involved a catalogue of errors and delay, I think it's safe to say. The paragraph on which the respondents rely is paragraph 82.5, which is on page 377. It is a subparagraph to paragraph 82, which starts on page 376, where the judge says, my conclusion is that CPR 310 cannot assist the claimant in this case. And then he goes on to consider the various factors arising in that case. And in 5, if I could ask you just to read subparagraph 5, because that's what's relied on by the respondents. So again, in my submission, all this simply says is that the limitation defence was one of the factors taken into account by the judge in the exercise of his discretion. Certainly does not say that that is the only factor that should be taken into account, nor does it say that it is a factor that defeats all others. Obviously, everything turns on the facts of each particular case. So when one is exercising discretion under 310, and then, if I may, the exercise of the discretion in this case, because the respondents do ask this court to exercise its discretion and not to make an order under 310. And we say that in the exercise of its discretion, this court should have regard to following matters, particularly as regards the argument that the defendants will be caused prejudice by the loss of their limitation defence. And I'd just like to make the following points. The claims in these cases are for damages for the unlawful implementation by Visa and Mastercard of what are known as multilateral interchange fees. You'll be familiar with that. The claimants have paid MIFs, multilateral interchange fees, for many years and continue to do so. And as of today, Visa and Mastercard continue to impose MIFs on the claimants, among all other merchants. Obviously, for the purposes of limitation, the claimants can claim for damages caused by the MIFs imposed in the period 6 years prior to the date of filing, as well as the losses which continue to accrue. If these proceedings have come to an end, as the defendants assert, then subject to the application of the Visa undertaking, the claimants can issue new proceedings, making new claims which go back from the date of those new claims for 6 years. And in fact, the claimants did issue such protective claims against Mastercard last August. In August this year. Last August. Therefore, the defendant's purported limitation defence is not about knocking out claims entirely. It is simply about reducing the length of the claim period and the quantum of damages claimed against them. And that is so where, on the other side of the balance, on the other side of the balance, the Supreme Court, as your Lordship will be aware, has held that multilateral interchange fees are unlawful under Article 101 of TFEU and the equivalent English provisions under Chapter I prohibition.
I'm sorry, it's the particular MIFs in that case were unlawful. It's not that all MIFs, as a matter of course, are unlawful, because they are actually permitted under a European regulation.
The
You don't need to emphasise that point, Mr. Hoskins.
No, the particular MIFs claimed in the Supreme Court, which are, at least to a certain extent, the same MIFs claimed.
You will
in
be
these
arguing
cases.
that there
And
is
I
no
will be
material
arguing.
distinction between those
And in
MIFs
fact,
and
have
these
on a
MIFs.
number of occasions, my lord. But in any event, there is Supreme Court dicta. The extent of that is under discussion is before the courts, but there is a Supreme Court dicta that the charging of those MIFs, at the very least, is unlawful. We say the claimants have prima facie meritorious claims for damages, at least as regards those MIFs, if not the rest of the MIFs as well.
Yep.
Also, it's important to recall that the circumstances of this case, Visa and Mastercard had specifically agreed that the time for service of the claim forms could be extended. And they had agreed that on a number of occasions. So that all the parties could await the outcome of the Supreme Court judgment. And they agreed those deadlines freely, and one would assume in full knowledge of the implications that agreeing those extensions of time for service would have as regards the periods of loss for which the claims were made, increasing the quantum of the claims by extending the claim periods. Moreover, the defendant's solicitors say in evidence before the lower court that they would have agreed with a further extension of time had they been asked for it on the 17th of July. Sorry, Visa says that. It's in the judgment of Mr. Justice Morgan. Paragraph, I'll get you the paragraph reference, I think it's 87. So we say that that is the limitation defence that is at issue here, and those are the circumstances. You can't just say, it's very much turns on the circumstances of this case. And we say it's not enough to outweigh the other factors which strongly support an order being made to remedy errors under 310. First of all, the error consisted in serving the amended claim form without a court seal on it. And when exercising its discretion in this case, the court should take into account the fact that, as Mr. Justice Morgan held in paragraphs 76 and 77 of his judgment, on the 17th of July, the defendants were clearly aware in these cases that proceedings had been issued against them. And I use that language advisedly because that is what was found by Mr. Justice Morgan. At the very least, they were aware, he says, of the contents of the claim forms and the nature of the claims made against them, and they knew the claim numbers from the previous original claim forms. Moreover, as I've also shown you, told you, and given you the references, by that date, the 17th of July, the defendants had also been served with the 30-page particulars of claim, setting out the claimant's case in some detail, together with quantum schedules, itemising the damage alleged. So the error itself, that is the failure to serve a sealed amended claim form, we say the error itself did not directly prejudice the defendants. What prejudiced the defendants is that if the court does not remedy the error under 310, if the court does remedy the error under 310, that deprives them of the opportunity, the windfall opportunity, as described in the cases, to plead a limitation defence. And the claimants lose at least part of the claims which we say are prima facie good claims given the judgment of the Supreme Court. Finally, on the exercise of discretion under 310, I would like to take your Lordship's ladyship back to the City Sprint judgment, because as far as I have been able to find out, that is the only case, only judgment under the electronic working pilot, where the electronic working pilot was used, in which CPR 310 has recently been applied. There are other cases, such as the Good Law Project, which was not a working pilot, electronic working pilot case. But City Sprint is relevant, and that's the authorities bundle tab 23, which says particular relevance.
Why is the Good Law Project not a CE file case?
It was judicial review, yes.
Because it's a JR.
Yes.
It wasn't it's only a JR and not a procurement claim. So
I think that's right. It certainly was not served under PD 51.0. Certainly didn't apply in that case, as I understand it.
yeah, you're quite right. Yes.
So, so City Sprint is at tab 23. And I've told you the background to that case. And if I could take you to, first of all, where the judge, Mr. Justice Fraser, addresses the exercise of discretion. If I could take you first to paragraph 43, page 468, and ask you to look there at the 6 factors that he says are important points when coming to consider relief. That is relief granted under 310. I could just ask you to read that. So, my lord, we say that each of those 6 points, except paragraph 3, which was subparagraph 3, are equally relevant.
3 isn't a particularly good point, is it? Because solicitors who regularly practice in these courts should know that the approval date may be a later date than the issue date, which actually gets put on the seal.
But it's not a point that's
Doesn't
live in this
affect
case
anything
anyway.
here.
The other points we say are equally applicable to the present case. The first point, subparagraph 1, makes it clear that in City Sprint the unsealed claim form was sent to the defendants. At that stage the sealed version was not available.
Yeah.
Equally, in our case, the unsealed amended claim forms were sent in time. The points made in paragraph 1 is that the unsealed claim forms were sent in time. The second point in paragraph 43 is there was no difference at all between the unsealed version provided on the 27th of July and the sealed version sent on the 5th of August. They were identical. The same applies in our case, identical except for the presence of the seal. Paragraph 3 is not applicable. Paragraph 4, subparagraph 4, both versions of the claim form, which was sent by FGS to BBLP, included brief details of the claim, running to 18 paragraphs, identical and relatively comprehensive. And I've made the point that our claim forms were served with full particulars that were comprehensive. Subparagraph 5, BBLLP acknowledged receipt of the unsealed version, and there's no doubt it was received. The defendant was therefore fully aware of the claim and the details of it from then onward. There is no doubt in this case that the defendant's solicitors received the emails attaching the unsealed claim forms on the 17th of July. Moreover, in this case, an extra point over and above what was relevant in City Sprint is the defendants were by that stage already in possession of sealed claim forms by way of information and had engaged in correspondence using the claim numbers, which were the same claim numbers that appeared on the unsealed claim forms served on them on the 17th of July. The fifth point is that the sixth point is that the defendant solicitors, BBLLP, were instructed to accept service of proceedings, had been specifically asked this and had communicated it. FGS therefore served upon the correct party, the defendant solicitors. In the present case, the respondent solicitors were both asked if they would accept service by email and confirmed that they were instructed to do so. So the service of the unsealed amended claim forms was served upon the correct parties in the agreed way. And moreover, in the present case, the deadlines for service had been agreed between the parties, extensions of time, and so the defendants were fully expecting service on the 17th of July. But then, if I could ask you to turn to paragraph 59 of the City Sprint case judgment.
Sorry, which paragraph?
I'd ask you to turn to paragraph 59, which is on page 472.
Ms. Smith, I'm afraid, forgive me, I've forgotten what order the judge in that case, Fraser J, was actually being asked to make.
He was being asked to make an order inter alia, among other things, an order under 310.
Not that far.
Yeah. And I think, although it doesn't actually spell it out.
I think the reason I'm asking...
Yes, he was also asked as an alternative.
No, I don't...
Sorry.
It's what order it was. I know it was under 310. What was he actually being asked to do? The reason I asked the question is because, as I understood, the problem in City Sprint was a bit more complicated because there was the 27th of July,
Yes.
which was the date of submission.
Yes.
There was the 29th of July, which was the date the fee was paid,
Yes.
and that was the date of acceptance.
Yes.
And at least on one view under PD 51.0, that should have been the date that it was deemed to be issued and sealed. Because
Well,
the rules
if
say
I may, I'll come back to that point
that's
and
one of the
yes.
points in the case. But there's 27th July, then there's 29th July, then they served the claim form within 7 days of the 29th, which
Yes.
is too late for the 27th.
Yes.
The trouble was there was also another problem because there was a prior problem with the 27th, the 29th. So what I'm trying to understand is what exactly it was the judge was being asked to do, not how he was being asked to do it, but what was he being asked to do?
What he did, he says, is paragraph 60. What he was being asked to do, I'm not entirely sure.
Okay, well, what did he do?
Paragraph 60, last sentence, he says, I am simply making an order that service of the unsealed claim form on the 27th of July should count as though it was service of the sealed version of the exact same document.
Thank you. That's the answer.
And that is effective, which is what I was about to ask you to read, not just paragraph 59, but also paragraph 60, but we got there in the end. So if I could ask you to read paragraph 59 and 60.
things I find difficult with this case. You go to paragraph 53.
Yes.
He says, timing makes it clear that the sealed claim form was already in existence when the unsealed copy was sent. The sealed claim form was simply not available to FGS to download 1727 on the 27th of July, even though it had been issued because of the outstanding payment. Proceedings had, however, clearly been commenced by them because the claim form had been issued and the seal had been applied. So it looks as though it was different from the present case in that at the time when they actually served the unsealed claim form, there was a sealed claim form. It just hadn't.
Well, my lord,
found its way to them.
I'm not sure that's quite what happened. I think this is, and I was going to return to this in reply, but I can make the point now, the interpretation that the judge made of the practice direction in this case, in City Sprint, and also I would say the interpretation that the judge made in Dory, which we also argue, which is that what is clear on the facts of City Sprint is that the claim was filed, submitted on the 27th. It was looked at by the court staff. They got back to, I'm not sure exactly when, the solicitor saying you've paid the wrong fee. She rectified that, and then the sealed claim form was the claim was accepted after she had sent in the fee on the 29th. But the judge read this as being, in effect, a claim form, a valid claim form, having been in existence from the 27th.
Well, I'm not sure that's right. Because he's got in mind, hasn't he, in 53, what Mrs. Justice O'Farrell said in the Pharmaceuticals Direct. I mean, which is the Pharmaceuticals Direct case? Because there are two Mrs. Justice O'Farrell cases, aren't there? There's Boxwood. It's not that one. Is this the Good Law Project?
Yes, it is.
Oh, yeah. So, where she obviously said there were non-existent proceedings. So
Yes.
he's saying, well, this isn't a case of non-existent proceedings because there was a sealed claim form in existence. But if you're right on the court staff didn't accept the claim form until the additional fee was paid, which does indeed seem to be the case in
Yes.
55, then I'm puzzled as to how there can have been a sealed claim form in existence on the 27th. Or at least days before the 29th.
I had read the judgment as being that coming from his reasoning in paragraphs 8, 19 onwards, where he talks about timing and dates. He talks about whether the claim form should have been held to have been issued from the date that on the face of the electronic seal, which was the 27th of July, that's paragraph 20, rather than the date on which.
He says it twice, he says it in 19 again. The period between the 27th of July, brackets, the date when the claim form was sealed electronically, close brackets. Same point as he's saying it's in 53. And he may or may not have been right factually about that. That may have been a misunderstanding by Mrs. Justice Fraser of the rules, or of the practice direction, or of what actually happened in fact. But he certainly seems to have proceeded on the basis that there was a sealed claim form.
Or it might be a compressed way of referring to the effective practice direction.
It might be, but
I
it's
think
not
it was,
clear,
my lord,
is it?
because if you look at paragraphs 5 and 6, paragraph 6 makes it clear that it was only at the middle of paragraph 6, only after receipt of the £528, the extra bit of the court fee, that the sealed claim form was uploaded by the court to the CE file system. It was, so that was the 29th. So the approved date is the 29th.
But that, if I may say so with respect to the judge, seems to me to proceed on an erroneous understanding of how the system works. You don't upload sealed claim forms into the CE file system. You seal them inside the CE file system.
Yeah.
That sounds
Yes.
like someone who thinks that what you do is stamp a form and then scan it and put it in the system. But that's just simply not.
Yes,
simply
well, and my lord,
If it's a word-based system as opposed to an electronic system.
yeah.
Indeed, as the judge says later on, the claim form has the electronic seal upon it, applied by the e-file system.
Yes, paragraph 6, yeah, the end of paragraph 6, the judge says the claim form itself has the electronic seal upon it, applied by the e-filing system the day the submission was checked as being in order, which is what generates the e-filing response saying a document has been successfully submitted, which was dated the 27th, but it was not successfully submitted until the proper fee was paid, which was on the 29th, but it had on its face, or it was backdated to the 27th of July. Now, what I understand and what I will say in reply or now is that the approach taken by the judge in Dory, paragraph 97.2 of his judgment, and the approach taken by the judge in this case was that the correct
In this case, you
meaning...
mean
Sorry,
City Sprint.
City Sprint. The correct meaning of paragraph 5.4, subparagraph 5 of the practice direction is that a claim form is issued when it is filed or submitted, and it is validly issued until it is held. It is a validly issued claim form until held otherwise. It is an issued valid claim form unless it fails the acceptance process. It does not become retrospectively valid on the point of acceptance. It is retrospectively invalidated. And that is the correct process when you look at, that is the correct reading of paragraph 5.4 of 5 of the electronic working pilot, which says that the date and time of issue of a document submitted by electronic working will not be delayed by acceptance unless the submission fails acceptance. So it exists before acceptance unless it is retrospectively, unless it fails acceptance and is retrospectively invalidated. And that we say is
5.4.
5.45. That is, we say, a sensible and reasonable and correct interpretation of the electronic working pilot, because in the vast majority of cases, as was the case with every amended claim form in our appeals, generally documents are accepted and they are treated as valid from the date in which they were filed. They're treated as issued and valid. It's also consistent, and this is another important point, with paragraph 2.1 of the pilot, which says that in terms, paragraph 2.1, we looked at this, but I wasn't at that stage alive to the importance of the language. 2.1, electronic working enables parties to issue proceedings and file documents online 24 hours a day, every day, all year round, including during normal court office hours. So if proceedings can be issued outside court hours, it is the filing that issues the document. And it is only if the issued claim form is subsequently fails acceptance that it is retrospectively invalidated. If that were not the case, you could not issue a claim form outside court hours.
I understand why 2.1 means what it says, that you can issue out of hours, but I don't understand why that tells you anything about which way round the deeming provisions are talking about.
I say it is consistent with the paragraph 545.
Yeah, it doesn't also, none of this deals with what it is that Mr. Justice Fraser meant in 53 and 60 when he talks about the claim form having been sealed. Being in existence sealed. Now, I understand your point. I fully understand your point. Whether it's an answer is a different question.
Yes.
But I follow the point that you can say on CE file, as of the 17th of July, on CE file, there were in existence amended claim forms for these cases, but they weren't sealed.
We say not only were they in existence, they were issued.
Well, whether
Yeah,
they were issued is a different question, but
that's-
what we're talking about here is whether they were sealed or not.
Yes. Whether they were sealed,
But they clearly weren't sealed, because they weren't sealed until
yes.
a later date, because nobody in the court office looked at them
My understanding
until
of
Monday.
yeah, yes. My understanding of, take this step by step. I may need to return to this in reply, but my understanding of the City Spring case is that the judge was, in effect, having found, which he considered in paragraph 17 onwards, that the date of issue, paragraph 20, he says there is no sensible way in my judgment for the date of issue of the claim form to be construed as anything other than the date provided on the electronic seal on the document, and that was the 27th of July. He held that the claim form had been issued on the 27th of July, but also retrospectively sealed. So the seal was in existence. That is my understanding of his judgment. My understanding of the judgment of Mrs. Justice O'Farrell in the Good Law Project is that although there was electronic service by email, I didn't understand that case, and I'll go back and double check this, but I didn't understand that case to have involved the electronic working pilot or the sealing of the claim form under PD 51.
Hang on a minute.
Oh.
Sorry.
And that I take from paragraph 44 of the court's judgment. Sorry, my lord, we're now jumping about, but it's in Authorities Bundle 21, Good Law Project. Paragraph 44, there's no suggestion here that this was under electronic working. 44 simply provides that the unsealed claim form was sent on the 27th of April. The claim form was issued on the 28th of April. Therefore, when the unsealed claim form was by the court office, therefore, when the unsealed claim form was sent, that's on the 27th, proceedings had not been started. So there's no suggestion that there was this, I understand.
No doubt we could find out if we actually had to, but I would take it from the case numbers heading in the two cases, Pharmaceuticals Direct and CE file, because that's what the HT 2021 and the 3 zeros, because for some reason, which no doubt my lord can tell us, but I can't, all the cases that are issued on the CE file either have 3 zeros in front of the number or 4.
Oh, my lord, that might be correct, but there's certainly, as far as I am aware, no mention of the practice
Well, you're
direction
absolutely right, there's no
in the
mention,
judgment
you're right.
of the
There's no
judgment in
mention,
Good
but
Law Project.
It may be that it was dealt with under CE, I don't know.
I don't know.
Anyway.
There's certainly no discussion of the implications
No.
of electronic working. The claim forms were emailed, but that is the extent to which the electronic element entered into the case, the reasoning of the case in the Good Law Project.
Right, so that's City Sprint.
Yes, my lord, just sorry, we were looking at paragraphs, if I may, just to tidy up that point. We were looking at paragraphs 59 and 60
Yeah.
before I close on this ground too. I would like to just simply go back to those paragraphs, which are paragraph 20, tab 23, page 472 and 473.
Yeah.
And I would ask you to highlight the fact that in paragraph 59, the prejudice to the defendant that was faced in this case was having to face a claim, which is reasonably arguable on its face. That is not prejudice as a result of the procedural error. In my judgment, the defendant is attempting to take opportunistic advantage of limited errors of procedure to achieve a technical knockout. Rather ironically, the defendant would be content if post had been used, but not email. Again here, this is really an attempt by the defendants to achieve a technical knockout. They say, had you asked for a further extension on the 17th, we would have agreed it, or Visa does. Had you served the original sealed claim forms, we would have accepted those, but we're going to take advantage of the fact that what you sent us was the unsealed, amended claim forms to achieve a limitation defence. We also would emphasise what is said by the judge in paragraph 60 about the effect of the order under CPR 310, which is not to extend time, but to make an order basically correcting the error of procedure that service of an unsealed claim form should count as though it was service of a sealed version on the exact same document. So weighing up all those factors, we say that the balance is clearly in favour of the court exercising its discretion in the present case in the favour of the appellants and making an order under CPR 310B rectifying the error insofar as it existed in serving an unsealed amended claim forms. My lords, my lady, I was proposing to address the Viva's undertaking in reply, the cross appeal, but so in that case, those are my submissions.
I'll take the mask off.
It's not much fun, is it really? I'm
No.
sorry about that.
Well, it means we all get to see each other.
In court, we could have made
No, absolutely. I'm a fan. Mr. Kennelly and I have split up our work, and I'm going to address you on the first ground. Mr. Kennelly is going to address you on the second ground, and obviously the visa undertaking, which is specific to his clients. So I am dealing with whether service of an unsealed claim form can ever, as a matter of law, be valid service. That's the short point. And there are really two aspects to the appeal on this ground, two arguments. First of all, it said that the judge was wrong to find that as a general rule, with the practice direction electronic working, that a claim form must be sealed. So a sort of general law point, if you like. And then it said that if the appellant fails on that argument, then the way it's put is that the general rule has been displaced by the practice direction electronic working, i.e. under the practice direction there is a difference from the general rule, i.e. that you can serve an unsealed claim form. So those are the two arguments that have been put. So let me deal first of all with the first argument, which is what's the general legal position absent the practice direction. And you've been through the CPR, so I can take this very quickly indeed. Authorities 2, tab 24. And our submission is, it is clear from the rules that I'm going to show you that the CPR, the whole system of the CPR is premised on service of a sealed claim form. First of all, at page 478, we've been shown CPR 6.2 sub C. Claim is defined as including any application to commence proceedings, and claim form is to be construed accordingly. Then at page 485, CPR 7.2 sub 1, proceedings are started when the court issues a claim form at the request of the claimant. Then CPR rule 2.6 sub 1, that's at page 476. The court must seal a claim form on issue.
Sorry, which rule is that?
2.6 sub 1 on page 476.
Was 487.
I'm sorry, 476 I.
486.
476.
Sorry, 476. Sorry, I thought you said 476.
Sorry.
Court must seal, yes, because you
Must seal the following documents on issue, the claim form. And then to complete this sort of scheme, taking us through from issuing to service, on page 486, 7.5 sub 1, where the claim form is served within the jurisdiction, the claimant must complete the step required by the following table in relation to the particular method of service chosen before midnight on the calendar day 4 months after the date of issue of the claim form. So after the date of issue of the claim form, i.e. issue of the sealed claim form. Other electronic methods, sending the email or other electronic transmission. In our submission, it's clear as day from that scheme that what must be served is the claim form as issued, i.e. the claim form as sealed. Indeed, the point was made this morning by Lord Justice Flo, under the general system where you turn up at the office, of course, it'd be meaningless to talk about service of the unsealed claim form because you wouldn't have one. Because you turn up at the office with your claim form and you file it, you issue it, you pay the fee, you get the sealed claim form. Of course, that's what you serve under the system. And equally, of course, if you were just to have a claim form that you hadn't even taken to the court office, and you were to serve that, that clearly would not be valid service under the system.
Well, if you're looking at the general rule, forget CE file for the moment. It's clear, isn't it, from reading 2.6 and 7.5 together, that the claim form that you issue must, by definition, be a sealed one, because the court is obliged to have sealed it when it issued it.
That's our argument. And you've seen that that's confirmed by the notes to the White Book. Again, you've seen these, so I can take them quickly. So we're still in tab 24. If we can go to 479, page 479. You'll see the heading, or the numbering 6.2.3 in the heading claim or claim form. Then if you go 1, 2, 3, 4 paragraphs down, it begins when a claim form is issued.
Yeah.
And if I just ask you to read that paragraph, please. So you see that what's the authors of the White Book are doing there is describing the court practice. And when they refer to Hills, they refer to it as describing the court practice. It's not that the authors are relying on Hills. They are here saying this is the court practice. There's a sealed claim form kept by the court. There's a sealed claim form given to the claimant. And then the final sentence, the general rule is that if service is to be properly effected on a defendant, a claim form in the second category, i.e. that's the sealed claim form provided to the claimant, must be served. So it couldn't be clearer that that is the court practice as described. And similarly, at 481, you were shown 6.3.2, and my Lord, you picked this up this morning, that what you find is a description or a discussion of the fact that under the general rule, you must serve, in inverted commas, an original sealed claim form, i.e. one handed to you by the court office. And generally speaking, a photocopy of the sealed claim form will not do. But the point that's being made is that even in circumstances where a photocopy of the sealed claim form is permissible, for example, email or fax, it's still a sealed claim form. It's always a sealed claim form under the general practice. And 6.3.2 also contains, according to the authors of the White Book, what they believe is the purpose, or at least one of the purposes of the seal. It's 5 lines down. The seal is intended to give a clear message to the defendant that he or she is being served with originating process by authority of the court and not being sent some informal demand. And in their submission, the claimants say, well, here, the original sealed claim forms had been sent for information. But with all due respect, the interpretation of the rules can't depend on the facts of this case. The claimants can rely on the facts of this case when they come to throw themselves on the mercy of the court under 310. But what they can't do is say, because on the facts of our particular case, this is this extreme position, you must do violence to the general practice. That really is a tail wagging dog. The need for service of a sealed claim form under the general practice, i.e. leaving aside the practice direction electronic working, is confirmed by the case law. Again, I can take this quickly because you've seen it. First of all, Cranfield and Bridgegrove, that's in Authorities Bundle 1 at tab 5. Cranfield and Bridgegrove is not easy to read through because it's a set of 5 appeals heard by the Court of Appeal at the same time, all with slightly different facts, which make it quite indigestible. But if I may, at the moment, just focus on the third case, which is McManus and Sharif. And if you look at the head note, opposite G, you'll see the facts of that case. In the third case, service was improperly effected within the time limit on the defendant's insurers. The defendant having requested that service be effected on him personally. The claimant conceded failure to effect proper service, but the judge granted an order dispensing with service under Rule 6.9, holding that on balance he should exercise his discretion in the claimant's favour. And it's also important to bear in mind that this judgment, 2003, again, it predates the amendment to the rules, these relevant rules that took place in 2008. So this is the former set of rules. If we can go to page 57. You'll get a bit more on the facts of the case, and you'll see that it deals with the service of an unsealed copy. So I can ask you to read paragraph 53, please. So you see here the inverted commas served an unsealed copy of the claim form, and then they served a copy of the sealed claim form after the event. But the short point is at page 59, bottom of the page, paragraph 57. There's a reference to Anderton's case, but it's what follows over the page. First, what was purportedly served was not the claim form issued by the court or a photocopy of that document, but a draft claim form. Thus, unlike the document issued by the court, it was not stamped with the court seal, and it did not contain a statement of truth. Rule 7.5 provides that after a claim form has been issued, it, i.e. the issued claim form, i.e. the sealed one with the claim number on it, must be served on the defendant. And it's fair to say that Rule 7. We don't have a rule in exactly the same terms as Rule 7.5, but the point I'm making is that under the previous set of rules, it was quite clear you had to serve a sealed claim form. And that's Court of Appeal authority under the previous set of rules. In our submission, it's quite clear that the requirement to serve a sealed claim form remains the same under the recast set of rules. Indeed, that's the rules I've just shown you in the opening of my submissions. But that is confirmed by Hill's contractors. Again, take it quickly because you've seen it. Authorities 1, tab 10. It's the judgment of Mr. Justice Ramsey. If we go back to page 169. So you made the point, and absolutely correct, that what was actually an issue in this case was whether you could serve a photocopy of the sealed claim form. What was not an issue in that case was the service of a sealed claim form acceptable or not. But what's quite clear from paragraphs 40 and 41, it's the same as the notes to the White Book. They confirm that the understanding of everyone, whether it be judiciary, authors of White Book, practitioners, is that you must serve a sealed claim form under the current CPR rules. And the judge below in our case, as Justice Morgan made the point, if service of a photocopy of a sealed claim form isn't sufficient, then it's absolutely obvious that service of an unsealed claim form won't do. If even a photocopy of the sealed claim form isn't enough in many cases, then you're not going to get to the races with an unsealed version. So we say that quite clear that the proper interpretation of the current version of the CPR is that valid service can only be effected by service of a sealed claim form. It's Nick suggested that there might be some difference where you are dealing with an amended claim form. But in our submission, again, it's quite clear that the fact that the claimant emailed unsealed amended claim forms in this case cannot remove the need for a sealed claim form to be served. And let me just make that good by sort of showing you 17.1 of the CPR. So I'm sorry, I've foolishly closed Authorities 2, tab 24. We can go back there. And it's page 490. CPR 17.1 sub 1, a party may amend his statement of case at any time before it has been served on any other party. And then sub 2 deals with the case, what follows after it has been served, you need to have permission. So before service, you can amend without permission. Now our submission is this. Rule 17.1 does not do away with the need for a party to comply with the requirements in CPR Parts 6 and 7 in relation to the commencement of proceedings. Put it another way, a claimant cannot avoid the requirement to serve a sealed claim form, which one finds in CPR Parts 6 and 7, by simply amending an original claim form without permission or consent, and then serving the unsealed amended claim form on the defendant. That would make a nonsense of the scheme of the rules. So quite simply, our submission is the rules of service must be complied with by serving a sealed claim form, whether that's an original sealed claim form or an amended sealed claim form. You can't escape that obligation. So that's our submission on what the position is under the general CPR as in force now. So we turn now to ask ourselves, well, is there an exception under the practice direction on electronic working? Does that practice direction create a new rule whereby you can validly effect service with an unsealed claim form?
Yeah.
And our submission, the answer is a resounding no. The practice direction, authorities 2, tab 25. Can we begin at page 493? Paragraph 1.2 sub 1 in the middle of the page. This provides electronic working works within and is subject to all statutory provisions and rules, together with all procedural rules and practice directions applicable to the proceedings concerned, subject to any exclusion or revision within this practice direction. So what's being made clear is that the general procedural rules of the CPR apply unless there is an exclusion or revision within the practice direction. And I make the fairly standard submission of general canons of interpretation. If the practice direction, if the authors of the practice direction had intended to depart from the general requirement of service of a sealed claim form in the CPR, they would have said so expressly. There is no exclusion or revision of the requirement for service of a sealed claim form in the practice direction. On the contrary, it confirms that requirement. And again, you've seen these provisions. Page 498. You see 7.1, the heading is electronic sealing. When the court issues a claim form, which has been submitted using electronic working and accepted by the court will electronically seal the claim form with the date on which the relevant court fee was paid, and this shall be the issue date. And then
that provision suggests, doesn't it, that in pretty strong terms, that nothing is sealed until acceptance.
absolutely, it says that in
So
terms
it's
of
when the court staff accept the claim form, whatever date that is, here it's the Monday and later dates, then that's when they, within the CE file system, put the seal on
absolutely
electronically, albeit that it bears the date of the 17th of July.
correct.
As at the 17th, 18th, 19th of July, there was no sealed claim form in existence.
Correct. That's in our submission. That's what
So whatever it
7.1
was
says in
Justice
terms.
Fraser was talking about, he seems to have been in error.
Well, to be fair, in City Sprint, there was the, I can't remember all the dates off the top of my head, so I think something like the filing was the 27th of July. The sealing, the acceptance and sealing took place, it's not quite clear, between the 29th and the 30th of July. And then service was on the 5th of August.
Yeah.
So the point is that was made in that case is by the time of service, the sealed claim form was in existence, but it was the unsealed claim form that was in fact served.
Well,
So I think that's the way that
yeah.
that case runs.
So it's 7.1 and then it's 8.1.
And you look at the heading of 8.1, service. This is the specific rule. The court will electronically return the sealed and issued claim form and notify the party that it, i.e. the sealed and issued claim form, is ready for service. It states in terms that what is to be served is the sealed and issued claim form. So far from an exclusion, an exception from the general CPR rule, the general rule is confirmed by Rule 8.1. You must serve a sealed claim form in order for service to be valid. And with respect to the reliance on paragraph 5.4 of the practice direction is, in our submission, misplaced. You'll see the heading for section 5 on page 496, general rules regarding issuing and filing, and contrast that with the heading on paragraph 7, electronic sealing, and the heading on paragraph 8, which is service. So 5.4 is not dealing with sealing or service. And there is a problem, even if one were to look at section 5.4 in its own terms as being relevant to service, because if you look at 5.4 sub 6, that provides if the submission fails acceptance, notice of the reasons for failure will be given to the party on that party's electronic working online account. And if the submission was of a claim form, it will be deemed not to have been issued. Therefore, in our submission, cannot be appropriate for a claimant to serve a claim form as filed in circumstances where it may subsequently be deemed not to have been issued. So it cannot be the case you can serve a claim form as soon as you've filed it. Now, that leads you to say, well, when can it be served? Well, it could be argued that it would be acceptable to serve the claim form as soon as it is accepted. But as I've already shown you, paragraph 7.1 provides that a claim form is sealed upon acceptance. So the relevant claim form for service would therefore be the sealed claim form. So even within the logic of 5.4 taken on its own, and forget 7 and 8 exist, the logic doesn't help the claimant. It has to be a sealed claim form.
Well, the 7.1 is the electronic version of what the member of staff at the counter does.
Yes.
Which is the claim form's handed in, it's accepted and sealed.
Yes.
And this is just doing it on the CE file instead.
Correct.
But the acceptance and the sealing are simultaneous.
That's right.
Mr. Hoskins, I don't know if you've spotted it, if I can put it that way. Can I draw your attention to Rule 15.3 of the Practice Direction, which relates to the update of the file, which I don't think has any bearing actually on either party's argument, but it has a bearing on the interpretation of some of the other cases we're looking at. What it says is that the file will be updated at acceptance, which is inconsistent with the idea that you could look on the file before acceptance, other than as the person who sent something in. I just wanted to draw that to your attention so that we can both review it and everyone else can take it into account if they think it matters.
Mike, I don't think it matters for my submission, and I have to just, I'm probably the worst person in the room to ask that question. I haven't checked with my solicitors, I hadn't spotted that paragraph, and I haven't asked that particular question, and you'll understand my practical knowledge of the CE filing system is dangerously inadequate, so I wouldn't want to mislead you by speculating. But certainly, obviously, if you want me to take instructions from someone who does know
We're going
Wales,
to get an answer on whether you can have a claim number assigned.
we believe the answer to
Before
that is no.
acceptance.
We believe the answer to that is no.
Well, I do too,
And that's, I have taken instructions on that in light of the discussion that took place this morning. You would get a claim.
Suggest likewise that you can't actually search for it, and it may be that obviously the person who's filed it, submitted it, may be able to do something, but certainly a third party, the defendant or anybody else couldn't.
Again, it would be inappropriate for me to speculate, but I can take instructions at that specific point if that would be helpful.
Mhm.
The position under the practice direction, i.e. you need a sealed claim form, is confirmed by Dory Acquisitions. So again, a well-trodden path, authorities 2 tab 16.
Yeah.
So I should, again, I think it is important, if you look at the front page on 290, the defendant was unrepresented and did not appear. I don't think you've had that drawn to your attention, but it's important I make that clear. And then if we can go to 296, we've seen paragraphs 24, 25, and 26 already. This is a CE file case, and you've seen the judge's comments on what could or could not have been seen on the file. But what's important for my submission is at page 303. The heading is defective service. And you'll see from paragraph 70 and 71 that according to Mr. Justice Bryan, in his view, without service of a sealed claim form, service will be defective. Now, again, I accept it. He says in 71, it is clear and accepted that attempted service was not valid service because it was unsealed, etc. And I've drawn your attention to the fact that the defendant wasn't represented, so not fully argued. So what one gets from this, it was clear to Mr. Justice Bryan that a sealed claim form was necessary, but I accept there will not have been full argument because the defendant wasn't there.
The defendant had been represented, the point would have been argued even more strenuously.
Yes.
Potentially.
So you might have gone even better, indeed, in terms of the defective service. But the point is with the cases is, it's one of these points, it's so well settled. It's, you can't find the blockbuster, but what the claimant, of course, can't find is the case that says they're right. Even all the cases, the High Court cases that deal with applications to remedy defective service, they all start on the premise that an unsealed claim form is defective. And then the question is, what can you do about it? There is no case in which there's an unsealed claim form and that is held to be effective service. It doesn't exist. Can I deal then with the practicality arguments? You have my submissions in a sense as a matter of interpretation. What is the CPR position as a matter of interpretation? What is the practice direction position as a matter of interpretation? You then get the sort of add-on, which is whatever the interpretation is, it should be altered according to the claimants because of these practicality issues that they have raised. Because that's the only way they can put that argument. And they rely on the following argument. They say that under the old system, your outdoor clerk comes to the office, you pay your money, you hand over your claim form, you get the sealed one back, you go and serve it. And they say under electronic working, there is a delay between filing the document and receipt of the sealed claim form. That's what they describe as the anomaly. And they say the extent of the delay in each particular case is not known in advance, and that creates uncertainty. And then the punchline, they say that because of that uncertainty, this court should interpret either the CPR and or the practice direction as permitting service of an unsealed claim form. Now, my first submission is that's quite the leap. I've shown you it's clear from the wording and scheme of the CPR and the practice direction that a sealed claim form must be sealed. The purpose of interpretation, which is what it is, which is proposed by the claimants, just simply doesn't get off the ground given the clarity of the wording and the scheme. But in any event, in our submission, the purposive argument is bad in any event. Yes, there may be a gap between filing and receipt of the sealed claim form, but there are a number of ways in which that can be addressed. For example, a claimant may file their claim form in good time, rather than waiting until the very last day for service before doing so. Secondly, a claimant may seek consent to an extension of time for service from the defendant. You see that happens on a number of occasions in these cases. Thirdly, a claimant may inform the court that the filing is urgent. So this is dealt with within the system itself. If you've left it to the last minute and you're worried you're running out of time, there is something in the system to help you. Can we go to supplementary bundle, tab 79? You'll see this is a document, a public document, CE file system information and support advice, guidance and support for people wanting to file documents online in the Royal Courts of Justice. And then at page 285, you'll see the heading Filing. The court will aim to process work received as soon as possible. Once your files have been accepted by the court, you can monitor the progress of your cases and see the sealed documents by searching for them via the CE file system. Again, another tantalising glimpse of what the answer to the bench's question might be and what you can see online. But the important bit is the next paragraph. It is the responsibility of the person filing the case to inform the court that the filing is urgent. When an urgent application is filed, the filing party will need to upload a letter with the document outlining the reasons why a case must be dealt with urgently. The filing party must also place a comment in the comments field stating that the filing is urgent. So even if you have left it to the last day and you are sweating, this is what you do. And the claimants didn't do that in this case. And the final example within this system of what a claimant might do if they are facing a problem is they can apply for an extension of time for service from the court under CPR Rule 7 sub 6. And such an application may be made preemptively or retrospectively. And if I were a betting man, I'd put quite heavy money on the fact that if you were to make a retrospective application where the delay of service of the claim form was entirely due to the court in some situation, I'm not saying that is this case, but if there was some extreme delay, the court would look favourably upon that application. But the point is, within this system, there are a number of ways in which you can deal with what the claimants describe as the uncertainty.
If the claimants had submitted their claim forms, let us say for the sake of argument, 10 days earlier than they did, and because of the pandemic, CE file staff were not processing the cases as quickly as they should be, then there would have been there could have been an application for an extension of time which would almost certainly been granted, either prospectively or probably retrospectively, because they could show that they'd taken all reasonable efforts to serve, and they would have acted promptly.
Correct.
The problem is turning up on the last day.
That's right. And that problem of turning up on the last day, it's not something that's specific to the CE working system. It applied in the old days. We all are familiar with the cases where the outdoor clerk, might have stopped for a beer on the way from the city before filing, got to the court office at 4:32 and the shutters are down.
Well, in the old days, you couldn't get a pint of beer at 4 o'clock.
Depends how far back you're going. But what the point is, if you leave it to the last minute, you run a risk, whether that's under the old system or the CE filing system. The fault does not lie in the CE filing system. You can't blame the system for that. You were referred, just a couple of just tidy up points in relation to matters that arose this morning. you were referred to the email exchange, so it's in the supplementary bundle, tab 47. The exchange between the claimants and the Civil Appeals Office about serving, what to do about serving the sealed notice of appeal. You weren't taken to CPR 52.12 sub 3. I don't know if you all have hard copies of the white book.
Yeah. CPR what,
52.12 sub 3. So it's on page 1855. Appellant's notice, then sub 3, subject to paragraph 4, and unless the appeal court orders otherwise. It wasn't that the person that sent the email was just making up the law. They were making an order otherwise pursuant to this power. You can serve the unsealed claim form now and you can serve the sealed one later. But the point is they were doing it pursuant to a power vested in them. And what the claimants then did with the appeal notice was pursuant to an order of the court. And then the final point I need to address on city sprints, I'm sure Mr. Kennelly will be returning to it in the context of Rule 3.10, but it was suggested that city sprint was a procurement case, and there are particularly short periods for service in procurement cases. But again, this is a tail-wagging dog submission in with respect. The fact there are particularly short periods in procurement proceedings cannot mean that the practice direction should allow service of an unsealed claim form in all cases. Indeed, it doesn't, as is clear from City Sprint, make service of an unsealed claim form acceptable in procurement cases, because the issue in City Sprint is, should there have been relief from defective service? So the answer to all of this is never, you can just serve an unsealed claim form. It's quite clear the answer is always, you have to serve a sealed claim form. So I've just been asked to point out, it sort of runs slightly counter what I've been saying on the facts of this case, because I don't want really to go near the facts of this case. But of course, there were at least 2 of the MasterCard claims that were actually filed on the 16th rather than the 17th. They were filed on the 16th, they were accepted on the 17th, the sealed claim form was available on the 17th, and they were served.
I had in my mind that there were some claims that were actually, where the claims forms were submitted even earlier than that, but have I got that wrong?
Again,
Anyway,
there were certainly 2
same,
that were
it's the same
done in
point,
time.
yeah.
I mean, it's your point, my lord.
Yeah.
You just do it in time and you don't have a problem. Unless there are any other questions, those are the submissions on ground 1. Thank you.
Please, the court, I'm addressing on ground 2, and just to recall the grounds of appeal, claimants' grounds of appeal. The first question is, was the court wrong to follow the judgment in Venus and Marks and Spencer's in preference to the obit dictum described by the claimants as the authoritative obit dictum, House of Lords and Phillips and Symes? And the second of 2 issues on the second ground is, alternatively, did the court err in its application of Venus in the present case? And if I may take you first to the relevant provisions of the CPR briefly, and I appreciate the court has looked at them many times, but just to recall what they are, because they're really central to the submission which I will make. And they're in the authorities one, but at the very back, on tab 24. And if I take you first, if I may, to Rule 310 itself, behind page 47, on page 477. And my simple point here, my lords, my lady, is that this is a general power of the court to rectify matters where there has been an error of procedure. If you turn over the page to 483, page 483 in the same tab, you see Rule 6.15, service of the claim form by an alternative method or at an alternative place. And as the court knows, looking at 6.15.1, under this provision, the court may make an order permitting service by an alternative method or at an alternative place where there is a good reason to do so. And the claimants, the appellants in this case, applied under this provision, and that was rejected by the learned judge below, paragraph 83 of his judgment, and they have not appealed that finding. And over the page 484, you see Rule 6.16, the court may dispense with service of a claim form in exceptional circumstances. And again, in this case, the claimants applied under this order, under this power, and the judge held that no exceptional circumstances existed to justify the making of such an order. That's paragraph 84 of his judgment, and there was no appeal against that either. And then at 487, you see the other potentially relevant provision, 7.6, well canvassed in the case law, an extension of time for serving a claim form. But the claimants didn't even make an application under this provision. It would have been under 7.63. And the question for the court, for this court, is whether the general power in Rule 310 may be relied upon in respect of a failure to serve a claim form within the required period in circumstances where a claimant cannot rely on the specific powers in Rules 615, 616, or 7.6. In our submission, this issue has already been determined by this court in the Venus case. And it's to that I now wish to go. It's behind tab 3 in the authority bundle. The court is obviously now very familiar with the facts and the rules in issue. And I'll go directly, if I may, to paragraphs 19 and 20. The Lord Justice made, the Court of Appeal is agreeing with the judge's conclusions. He says at 20, referring to the particular order for the provision for the extension of time 7.63, says the meaning is plain. The court has power to extend the time for serving the claim form after the period for its services run out, only if the stipulated conditions are fulfilled. That means the court doesn't have the power to do so otherwise. I'll skip Rule 3.12a, and then this. And this passage is of central importance to my submission. The general words of Rule 3.10 cannot extend to enable the court to do what Rule 7.63 specifically forbids. And that was read to you by my friend Smith earlier today. But she did not read the rest of the sentence, nor to extend time when the specific provision of the rules, which enables extensions of time specifically, does not extend to making this extension of time. And that passage in my submission is of general application. It is not limited to Rule 7.63. And there are 2 points to make about that. One is the point I've just made, which is it's not limited to 7.63. The second is that it was said by my friend that this principle only applies where it is claimed or where it is sought to rely on Rule 3.10 to do something which is expressly prohibited by another specific provision of the CPR. That is not what the Court of Appeal is saying in Venus. It is not referring only to bypassing express prohibitions. It says that a general power can't be used to extend time when the specific provision of the rules which enable extensions of time specifically doesn't extend to making this extension of time. So where another rule, a specific rule, doesn't permit the thing, it cannot be obtained under the general power in Rule 3.10. And we go then, if we may, if I may,
Where the rule doesn't, not only where the rule prohibits something, but where it doesn't permit it.
yes. And just completing the passage in paragraph 20, at the bottom of page 26, it would be erroneous to say that because Mr. Venus's case is a deserving case, the rules must be interpreted to accommodate a particular case. The first question for this court is not whether Mr. Venus should have a discretionary extension of time, whether there's a power under the CPR to extend the period for service of a claim form if the application is made after the period has run out and the conditions of 7.63 do not apply. And I rely on the passage just below B, about 4 lines down. If you then look up from the wording of the rules and at the broader horizon, one of the main aims of the CPR and their overriding objective is that civil litigation should be undertaken and pursued with proper expedition. If I may go then to the judgment of Lord Justice Peter Gibson, which begins on page 28, paragraph 26. It says the construction of the CPR, like the construction of any legislation, primary or delegated, requires the application of ordinary canons of construction. But the CPR, unlike their predecessors, spell out in part 1 the overriding objective of the new procedural code. If I may skip down, my lords, my lady, between H and J, I'll pick it up where he says, though in that context it should not be forgotten that the principal mischiefs which the CPR were intended to counter were excessive costs and delays. Justice to the defendant and to the interests of other litigants may require that a claimant who ignores time limits prescribed by the rules forfeits the right to have his claim tried. And then this at paragraph 27, upon which I place particular reliance. A principle of construction is that general words do not derogate from specific words. Where there is an unqualified specific provision, a general provision is not to be taken to override that specific provision. And then he goes on to address Rule 7.6 in particular. I would say in my submission, this Rule 7.6 is a fortiori. It's a specific subcode dealing with the extension of time in all cases, where the time limits in 7.5 have not been or are likely not to be met. The subcode sets out in some detail what the claimant must do if he wants an extension of time and the circumstances in which the court must exercise the discretion. And skipping down just above B, having ruled out 7.63, nor in my judgment could the general power in 310 to remedy a failure to comply with the rule be pressed into service to perform the like function of, in effect, extending time. Now, this was followed by the Court of Appeal in Elms, and that's behind tab 4 of the authorities bundle. It was followed and applied by this court in Elms and in the Cower and CTP limited case. In Elms, if you go first to paragraph 1, you see the particular problem that arose there. The question was where a claim form is served in time but incorrectly. It was served, a sealed claim form was served on time but on the defendant's insurers instead of on the defendants themselves. Is there a power in the court on the claimant's application under 310 and 6.8? And as the Chancellor noted earlier, that's the equivalent of 615 for our purposes, although the language changed. To remedy an error deeming the service to have been good service by an alternative method not permitted by the rules. And at 3, Lord Justice Simon Brown mentions that the judge below didn't have the benefit of the two authorities he says are directly on point, quoting, reciting Venus and Cower. before, he says, having set out the conditions in 7.63, the learned judge notes that the claimants were manifestly unable to satisfy those conditions, so they couldn't satisfy the conditions in 7.63. Yes, and Mr. Hoskins makes the point, this is a case of defective service, not no service. You'll see that later in the judgment. He cites Venus in paragraphs 6 to 9. There's no need to read that in detail. It sets out the passages that the court will already see. And then at page 33, in paragraph 10, he says at 10, the central and critical difference between the instant case and those two cases, and this is the submission made by Mr. Porter in that case, was that there had been service of the proceedings in time. He says that the applicant in that case said they weren't trying to bypass Rule 7.6. He only needed to have the service which is wrongly affecting defendants and insurers deemed nevertheless to be good service. And for that purpose, he's relying, as the court notes, more particularly on Rule 6.8 or 6.15 for our purposes. When we go to paragraph 30, we see why that submission was rejected. Justice Simon Brown says, although it's an attractive point, we skip down about 4 lines down. It implies that Rule 6.8, the rule which provides for service by an alternative method, can be applied retrospectively. And as we noted earlier, at that time, Rule 6.8 couldn't be applied retrospectively. That was cured, as the Chancellor noted, in the changes which led to 6.15. But he says this, if one asks what order the court is to make to rectify the mistake made here by the claimant solicitors, it can only be an order under 310, that an order for alternative service, not in fact made under 6.8, shall be deemed to have been made. The plain fact is that no Rule 6.8 order here was made, and of course there never was an application for alternative service, let alone for an order dispensing with service. Then he says, nor, it seems to me worth observing, would it ever have been proper to make such an order in this case. The order that was being sought, effectively under 310, was an order to treat an order for service by alternative methods as if it had been made, before service took place. And the learned judge said that was impossible. 3.10 couldn't be used to do something which could not be done in those days under Rule 6.8. He couldn't use 3.10 to bypass what he understood was the requirement of 6.8. And my lords and my ladies, you see in these cases, when the courts refer to not allowing 310 to do things which couldn't be done under a specific provision, those provisions aren't prohibitive. The provision, like 6.8, is facultative. There are conditions which, if satisfied, allow the court to make the relevant order. The point I make is that if you fail to satisfy those conditions, you can't rely on 310, do the thing which the specific provision does not permit.
Yeah, so in the words of Lord Justice Peter Gibson, it's where you have a subcode in the CPR which deals with a particular topic.
Indeed, precisely, yes. And then we go to Steele and Mooney, and that's behind tab 6. Here, as you've seen, this was an extension of time for service statement of the case. It was sought and ordered, but the claimants forgot to include a reference to the claim form in the relevant order. And the claimants applied, for the purpose of correcting the order, under Rule 310 only. If you go first, please, to page 77. And paragraph 24. My own friend Ms. Smith took you to this passage, and I rely on it also for the purposes of my submission that the principle of Venus is not limited to the application of Rule 310, where Rule 7.63 is in play. What the Court of Appeal state in clear terms in paragraph 24 is the general language of Rule 310 cannot be used to achieve something that is prohibited under another rule. And you have my submissions on how one should read the word prohibited there. That's the principle established by Venus and Marx and Spencer. And then we go to page, if we make 78. and the analysis of Lord Justice Dyson between D and E on page 78. Much of this the court has seen already. But we see how Lord Justice Dyson analyses this, because he says that between D and E, but for the reasons that we have given, the application of the 18th of February 1934 was not in substance an application for an extension of time for service of the claim form. It was in substance an application to correct the applications for an extension of time which were made within the time specified for service by Rule 7.52 and which by mistake did not refer to the claim form. To remedy the error contained in the applications does not circumvent their prohibition in Rule 7.6.3. There's no question of bypassing in substance something which is governed by a subcode under a different rule. And that's the point that my Lord the Chancellor made earlier when you said that here the remedy sought was to remedy a defect in the consent order. There was no Venus problem because no rule was being bypassed. The extension of time was in the order. There's no need to rely on 7.6. It wasn't a defect in service case. But here, what is sought in substance is to treat the service of the unsealed claim form as a step towards the service of a sealed claim form. In substance, what is sought is an order permitting service by an alternative method, which is governed specifically by Rule 6.15. And in paragraph 29, you see the Elms judgment referenced. And in paragraph 30, Justice Dyson says, in our judgment, Elms does not cast doubt on the reasoning we've expressed. In that case, the court held that an order for alternative service could not be made retrospectively under Rule 6.8, and that, applying the Venus principle, Rule 3.10 could not be invoked to do what was prohibited by Rule 6.8. And in my respectful submission, let me explore the point I made earlier. Rule 6.8 doesn't prohibit expressly anything. The conditions of it simply weren't fulfilled. And that, my lords, my ladies, is the body of the Court of Appeal's case law on this issue. It bound the language below and binds this court. The question then is it overruled by what the claimants say is the authoritative obiter dictum in the Phillips case? And it's to that then that I turn. I'm not going to take you to
say that point wasn't really pressed very hard orally.
and I shan't press it. I do
I
need
mean,
to take.
speaking for myself, in the light of Barton in the criminal division, it's a bit difficult to see how the point gets off the ground.
My lord, and I noted that my friend didn't.
I mean, I noted that in Phillips, true it is that these cases have been cited in the Court of Appeal, but they weren't cited to the House of Lords. We've got a list of the cases cited in argument. Don't include Venus or Elms or Steele.
When you've got clear Court of Appeal authority.
So the idea that somehow the House of Lords kind of sub silentio overruled decisions of the Court of Appeal which weren't even cited doesn't really need to be stated to be rejected.
And I shan't waste your time in repeating
I
that.
don't know my point of now. They may not, they may. They're looking very sceptical.
Well, then,
It's 4 o'clock, that's why.
well, I mean, I shan't.
Unless I don't think you need to develop that point, to be honest.
Well, then I shan't go to it at all. But does the court want to hear from me on the Phillips judgment?
Sorry?
Because the Phillips judgment was referenced.
Yes.
Shall I take? I don't want to waste your time. I could move on. But
Well, by all means, if there's anything you want to say specifically about what Lord Brown said, in the light of what Smith said, then by all means.
I'm grateful. I'll go straight. My basic point on this is that it's not only obiter, but it's inconclusive, because Lord Brown gave, and I mean no disrespect at all, very cursory treatment of the Rule 310 issue, because he was already plainly minded to apply what was then Rule 6.9. And you get that from a number of points, and I'll make these briefly. First of all, the court saw, and I'll do this without taking to the judgment to save some time, that there were 3 different errors of service in this case. This was a highly unusual case.
Yeah.
The first, as the court saw, was it's in paragraph 14. The High Court in England erroneously stamped the claim form as not for service out of the jurisdiction in circumstances where an order for service out of the jurisdiction had been made. The second error was that, and you see this in paragraph 20, the Swiss judge or clerk actually removed the English language claim form from the pack in view of what had been written on it. And there was a third error. You see this in paragraph 24. No documents at all were served on Nefer. Nefer was the third defendant in that case. But when you come to Lord Brown's analysis, and you see this in paragraph 31, he says, it seems to me at least arguable, that even without resort to Rule 6.9, the court could simply order under paragraph B 310 that the second and third defendants, that's including Nefer, who wasn't served with a thing, are to be regarded as properly served, certainly for the purposes of sizing. The error of procedure, which appears to be a reference to a single error of procedure, even though 3 of them, here was, of course, the omission of the English language claim form from the pack of documents served. For Nefer, of course, that wasn't the problem. It was that they got nothing at all. That doesn't invalidate any step. The relevant step was service of proceedings. And he refers to the Goldian Mariner, which I noted my friend didn't press. No analogy with the Goldian Mariner is pressed before you, and I shan't respond to that. But I will take this point in the middle of page 154. Lord Brown noted that in the Goldian Mariner, there was no rule like 6.9. So in the Goldian Mariner, there's no question of relying on the general power to bypass a specific provision. There wasn't a specific provision in play in that case, in the Goldian Mariner. And then at 34, you see why Lord Lawlord's judgment or analysis of 310 was so cursory, because he relies on 6.9 instead. There's no engagement at all, as the Chancellor noted, with the principle in Venus, Elms, or Stephen Mooney. So I'll move on from, that's all I want to say about Phillips. And really, my lords, that's the end of it. It should be the end of it, at least. As I said, Mr. Justice Morgan followed those authorities correctly, and they're binding on this court also. But there are a large number of High Court judgments, some following Venus, some Phillips, some trying to reconcile them, and as my lord noted, some of them haven't Venus cited them at all, and in particular 3 suffer that problem. Integral, which has been taken to Bank of Baroda, and indeed Dory. And for the purpose of my 310 submissions, the court can derive very little assistance from those judgments, which didn't have the benefit of the Venus approach put to them at all. So I won't take you to the detail of Integral for that reason, but I will, for your lordships and my ladies' note, simply ask you to record that in Integral, to the extent that the court's going to rely on it for any purpose, that was concerned with a particulars of claim, as my friend Ms. Smith explained. It wasn't concerned with service of originating process. And in Bank of Baroda, again, I shan't take you to the detail of it for 310 since it didn't consider Venus at all, but I do rely on for the purposes of prejudice, which I'll come back to when I develop my submissions under our respondents' notices. And if I take you to Bank of Baroda for that purpose, following the authorities in chronological order, it's tab 13, and page 236. Sorry, page 235.
So Venus doesn't seem to have been referred to.
certainly wasn't referred to in the judgment. And there's no suggestion it was cited, is there? We don't know. We don't have a list of other cases cited, but
No, there's no,
I can't now recall whether the form with the courts as they do refer to.
my lord, in Bank of Baroda, perhaps you're not asking about, you're asking about Integral or Bank of Baroda, my lord?
Bank of Baroda.
Bank of Baroda has the list of cases.
Yeah, what I'm saying is I don't know whether the All England practice is to give lists of cases that were cited in argument as well.
I understand, my lord. I don't know if it was put, but
Well,
more,
don't worry, I'm sure we can.
I mean, more importantly, my lord, even if Vino's hadn't been cited, had there been a discussion about the question of statutory construction, that would be something. But there's no engagement with that principle.
There's no discussion of the point.
But I do rely on it for the purposes of prejudice. And if you go to page 235, sorry, yes, 235, paragraph 18. So, contrary to my submission, and I'm relying on this in the alternative if I'm wrong about the basic point I'm making, but I'm taking you to it since we're here. Should it be applied? And there's no suggestion, says the learned deputy, as was in those days, that the defect in service had any prejudicial effect. The defendants were effectively informed the defective attempt at service, the proceedings had been commenced against them. I'll come back to the relevance of that when we look at Barton. Nor was it argued that there was any limitation issue. And that shows that limitation can be relevant prejudice for these purposes. And I pick that up again at the bottom of that page, 235. The last three words, the very end of the paragraph. Given the fact that no limitation point arises and the effect of the order will be to validate steps taken before the claim form expired, the learned deputy says, I don't consider the expiry of the claim form stands in the way of this order being made. I'll move on then, if I may, to Peoplebrook. I'm not going to take you to Dory. I think that's been fully explored with our friends. Peoplebrook is behind tab 18. And it contains a useful summary of the authorities so far by Mr. Justice Nicklin.
Yeah.
And he makes the point at paragraph 1. This is not a case about the problems that can arise when a claimant leaves service of a claim form to the last moment. Litigant who does so courts disaster, as Lord Sumption said in Barton. Then at page 363, if we skip on to 7 point, we see the rules that were relied on in that case, and the court has already got the point that there was a defect in service in that case, and these were the rules that were sought to be relied on by the applicant. 7.6 we see at 363. If you skip on to page 367, you see that the applicant also tried to rely on 6.15. And if you skip on, you see the applicant in that case also sought to rely on 6.60 and 372. The applications under 7.6, 6.15 and 6.16 all failed. And then we have a paragraph 74, the final reliance on 310. And we take it up from paragraph 74. The claimant seeks an order under 310, remedying his error in not validly serving the claim form. The defendants submit that 310 cannot rescue the claimant. This general provision does not enable the court to do what 7.63 forbids, and I would add 6.50 and 6.16. Ms. Morzek argues 310 provides a mechanism where the court, when it sees the claim, can cure defects in procedure, defects in serving process. This can be done only under 6.16. It says he retracted the submission, but there are authorities he has to consider. And if we can skip through those, my lords, he considers integral. He goes to we go to paragraph 81 in page 376, and the learned judge notes that integral and Baroda were decided before the Supreme Court decision in Barton. comments as to whether 310 can validate an error in serving a claim form strictly obiter. And there's a consistent line of authority that suggests that CPR 310 cannot be used to rescue a claimant who, having failed to serve a claim form via a permitted method, cannot bring himself within CPR 7.6, 615 or 6.16. And then he says, my conclusion is that 310 cannot assist the claimant in this case. Barton is a clear statement of the underlying principles as the importance of serving a claim form in accordance with CPR. 310 wasn't referred to in Barton, but would be an obvious solution in that case had it been applicable. 310 is given an interpretation that permits the court retrospectively to validate service not in accordance with CPR on the basis it's been a favourite type of rule. And that would make CPR 6.15 redundant. That'd be a surprising result as to the terms of CPR 6.15 are of specific operation, whereas 310 is of general application. Further, as noted in Godwin, the effect would be tantamount to giving the court a discretionary power to dispense with statutory limitation periods, contrary to the clear policy statement in Barton. Then Steele and Mooney appears to contain the clearest pre-Barton statement that 310 can't be used in that way. It gives the court a discretion to exercise it in accordance with the overriding objective of dealing with cases justly. If remedying one party's error will cause injustice to the other party, the court is unlikely to grant relief under the rule. This gives the court a necessary control to ensure the apparently wide scope of 310 is cause unfairness. Again, this critical principle, the general language of 310, cannot be used to achieve something that is prohibited by another rule. And that's the principle established by Venus. And he notes that integral wasn't a case involving service of virginity process. Like a Baroda was a case where there was no prejudice to the defendant. And the deputy judge acknowledged that 310 might not apply where what was sought to be corrected was service directly contrary to a rule. Here, in contrast, the expiry of the limitation period means there is significant prejudice to defendants if 310 validates the error of procedure and the claimant's service of the claim form was directly contrary to, or at least not permitted by, 6.7 and so forth. I'll stop there if I may. I have one more, I mean, I don't want to try your patience, I have one more authority to take you to.
Why don't you do that in the morning? But we've got, I think, is the one more authority Boxwood?
No, I was actually.
Boxwood is another case which I think recollections right follows people, doesn't it?
Exactly.
Follows this
line of authority. Yes.
In this case as well.
Yes. There's a useful analysis in Serbian Orthodox Church and Kesar, which comes after Boxwood.
Yeah.
I was going to take you to that, and then very briefly to City Spring. Mr. Hoskins has addressed you on that, so I just need to make two very short points about that.
Yeah. Okay.
And then I'll move on to my fallback, which is, if I'm wrong, how the court should exercise its discretion.
And you'll deal with the.
We're well aware of the injunction from the court.
No, I think it wasn't intended to be prescriptive, but it was just at least the court's hope that we could deal with it in a day and a half.
We're making very good time.
I think we are making good progress. Very well. 10:30 in the morning.
Rise.